Long before the Citizens United case, the Supreme Court had already ruled that the anti-corruption rationale was a losing argument. In a 1976 case called Buckley v. Valeo, the Supreme Court ruled that the government's interest in preventing corruption did not justify banning or limiting independent political advertising. In the court's own words, independent advocacy does not presently appear to pose dangers of real or apparent corruption comparable to those identified with large campaign contributions. Unlike contributions, such independent expenditures may well provide little assistance to the candidate's campaign, and indeed may prove counterproductive. The absence of prearrangement and coordination of an expenditure with the candidate or his agent not only undermines the value of the expenditure to the candidate, but also alleviates the danger that expenditures will be given as quid pro quo for improper commitments from the candidate. In other words, although the government may have a compelling interest in preventing government corruption, a law which prohibits independent political speech by corporations is not narrowly tailored to prevent corruption. It fails because of overbreadth. It restricts speech which does not cause corruption. So the anti-corruption rationale fails. The anti-distortion rationale was adopted by the Supreme Court in a 1990 case called Austin v. Michigan Chamber of Commerce. In that case, the Supreme Court decided that the government had a compelling interest in preventing the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public's support for the corporation's political ideas. In Citizens United, the court re-examined its decision in Austin and ruled that the anti-distortion rationale could not justify a ban on corporate political speech. Now, I apologize for what probably seems like endless subdivisions and subcategories, but to fairly evaluate the anti-distortion rationale, it is important to understand each of the three elements of this rationale. 1. Immense aggregations of wealth. 2. The help of the corporate form. And 3. Little or no correlation to the public's support. The first subreason, that corporate political speech should be banned because corporations can spend immense amounts of money to influence public opinion, is a restriction based on the identity of the speaker. Consequently, any restriction of this kind will be subject to strict scrutiny. This means that the government must present a compelling government interest in restricting the speech, and the restriction must be narrowly tailored to serve that interest. Even if the government has a compelling interest in restricting corporate political speech because of the corporation's wealth, a blanket restriction on corporate political speech for such a reason is a clear example of a law that is not narrowly tailored. It is certainly true that there are some corporations which have immense amounts of money available to spend influencing public opinion, but there are many more which do not. So the law is overbroad. Furthermore, restricting corporate speech does not prevent individuals who have immense wealth from influencing political campaigns, so the law wouldn't serve its avowed purpose anyway. More importantly, however, it is inconsistent with the principles of the First Amendment to ban speech because of the speaker's wealth. Campaign season would probably be more pleasant and calm with such a rule, but the First Amendment would be violated. In the words of the Supreme Court, the rule that political speech cannot be limited based on a speaker's wealth is a necessary consequence of the premise that the First Amendment generally prohibits the suppression of political speech based on the speaker's identity. So the first subreason fails. In my opinion, the second subreason, that corporate political speech should be banned because corporations enjoy special privileges and protections due to their corporate form, is the most persuasive. Corporations benefit from three advantages relevant to their involvement in the political process which individuals do not have. Perpetual existence. Corporations don't die until they stop making a profit and run out of money. Limited liability. When a corporation violates someone's rights and gets sued, for example for defaming a political candidate, the individuals who invested in the corporation are not personally liable. In other words, if a corporation is sued, the investors will only lose the value of their stock and not their other personal assets. And the ability to easily distribute and accumulate assets. But these advantages do not justify banning corporations from speaking about political candidates during campaign season for two important reasons. First, these advantages are offset by limitations inherent in the corporate form. Although corporations exist as long as they make a profit, they have no independent will, so whenever the owner or board of directors changes, the corporation's will changes too. The advantage of limited liability is also offset by the fact that if a corporation is bankrupted by a lawsuit, it ceases to exist and can never speak again. Individuals run no such risk. They can go broke, lose all their money, and live to fight another day. The ability to easily distribute and accumulate assets is likewise constrained by financial regulatory laws and corporate officers' fiduciary duties. Individuals have no such restraints. The second reason that these advantages do not justify banning corporate political speech is that corporations are essentially groups of individuals who have pooled their resources to facilitate commercial success or some other goal. These individuals undoubtedly enjoyed virtually unrestricted First Amendment rights to speak independently about political candidates before they chose to form a corporation, and the fact that state law granted to these groups of individuals the ability to form a corporation does not justify a federal law which restricts their First Amendment rights. As Justice Scalia wrote in his dissenting opinion in Austin, "It is rudimentary that the state cannot exact as the price of those special advantages the forfeiture of First Amendment rights." So the second subreason fails. The third subreason of the anti-distortion rationale, that corporate speech enjoys little or no public support, is so contrary to the purposes of the First Amendment that it scarcely merits discussion. Uniformity and agreement have never been prerequisites for speaking about politics. That this is one of the more popular elements of the First Amendment is evidenced by the many lawn signs and bumper stickers which announce ad nauseum that dissent is the highest form of patriotism. The fact that corporations fund their dissenting opinions with money extracted from commerce is irrelevant. As the Supreme Court pointed out, it is irrelevant for purposes of the First Amendment that corporate funds may have little or no correlation to the public's support for the corporation's political ideas. All speakers, including individuals and the media, use money amassed from the economic marketplace to fund their speech. The First Amendment protects the resulting speech even if it was enabled by economic transactions with persons or entities who disagree with the speaker's ideas. So the third subreason fails. Since each of the three subreasons supporting the anti-distortion rationale are fatally flawed, the anti-distortion rationale fails also. The final argument that the government offered to justify restricting corporations' political speech is shareholder protection. Solicitor General Elena Kagan argued in her brief to the Supreme Court that campaign finance laws were justified by the government's interest in protecting corporate shareholders from having their money used to support political candidates to whom they may be opposed. This is a very strange argument, not only because it assumes a remarkably paternalistic attitude by government towards shareholders, but also because it runs contrary to established rules for government review of corporate decisions. There are two ways that corporate expenditures for political speech might harm shareholders, financially and psychologically. Consider the financial harm concern. Corporations choose to speak about political campaigns and issues because they believe that by so doing they will promote an economic or regulatory environment favorable to their business operations. In other words, they are seeking to advance the financial interests of the corporation. Sometimes a corporation's board of directors may get it wrong and advocate the election of a politician who votes for laws which harm the business, but that doesn't justify government intervention. When courts deal with situations where a board of directors has made a poor decision, they apply a legal doctrine called the business judgment rule. This rule holds that a board of directors is not liable for a decision that was reasonable at the time it was made. In other words, when a board of directors makes complex decisions about what real estate to buy, what research to fund, or who to hire, the board's decisions are safe from judicial interference as long as they were reasonable at the time. The shareholder protection rationale would change this relationship in the context of political speech expenditures. Instead of deferring to expert business executives who make complex decisions about how to promote and protect their company's interests every day, the shareholder protection rationale assumes that in political matters, these executives would be so likely to waste shareholder money that the government is justified in prohibiting corporate speech about political campaigns altogether. The concerns about psychological harm are even less justified. Suppose that a corporation spends money to promote a policy or candidate which offends a shareholder. The shareholder has several options, which include selling her shares, altering company bylaws, and electing new company management. Importantly, none of these options involve violating the First Amendment. In short, the shareholder protection rationale is a blatant attempt to make a mountain out of a molehill, to indulge in the fiction of a compelling governmental interest where the government has no interest at all. But even if the shareholder protection rationale were a compelling governmental interest, the campaign finance laws challenged by Citizens United would fail because they are not narrowly tailored to further that interest. These laws are overbroad because they prohibit corporations and unions from speaking about political campaigns, even when all of the shareholders or union members support the speech. Family-owned corporations and single shareholder corporations are likely to fall into this category. Unions are also likely to fall into this category because many unions allow members to choose not to contribute to political action funds. But perhaps the best example is Citizens United itself. Recall that Citizens United is a corporation formed for the purpose of engaging in political speech. So the shareholder protection rationale fails because it is not a compelling governmental interest, and because the laws seeking to protect that interest are not narrowly tailored.